What's good for the goose is good for the gander is the popular idiom. That is to say that one person or situation should be treated the same way that another person or situation is treated. To correlate that with some of the leading judgments of our high courts in India, I would like to state that in POCSO, one of the judges was shunted out under the pretext that she has given a contradictory judgment violative of law. Whereas a similar kind of judgment, when it was pronounced by another judge, that event went unnoticed and the judge remained low profile and he even retired recently and going to spend peaceful life. So what it tells clearly is that the legal supervision which one say is good for the goose is not good for the gander. That's what the conclusion that one can make from the kind of anomalies that we are finding in our legal verdicts, because there is no proper supervision on the judgments of the higher court judges. Now let's see in detail what are all these two cases to compare and how one judge was punished and how another judge got scot-free in our today's bar and bench analysis. We all know that in 2022, Pushpa Ganediwala has made the headlines as a judge of Nagpur bench of Bombay High Court because she has delivered a judgment by stating that when there is no skin-to-skin contact, there is no sexual assault was her verdict. And the verdict was criticized by many NGOs, media trials took place and ultimately led even the Attorney General K.K. Venugopal criticized the kind of judgment given by the concerned judge Pushpa Ganediwala, and ultimately she has to resign just before one day where she was to go for her demoted position back. Justice Pushpa Ganediwala faced flack over a series of judgments that were deemed to be controversial for the interpretation that sexual assault under POCSO has to qualify for skin-to-skin contact with sexual intent. Without that, she said, POCSO is not going to be attracted. That was where she went into trouble with her verdict, which has become a big controversy throughout the country. Whereas, very surprisingly, a Bombay High Court judge by name Sandeep Kashinath Shinde in the year 2020 very silently delivered a verdict which is also a kind of verdict controversial like Pushpa Ganediwala. Let's see what Justice Sandeep Kashinath Shinde has delivered in relation to POCSO case. Justice Kashinath Shinde observed that 14-year-old is mature enough and granted bail to the accused. His main ground for granting bail to a POCSO accused is that 14-year-old survivor was mature enough and that the sexual act was consensual. On that basis, a bail was granted to the accused by the justice. Whereas, when we get into the facts of the case, it's so obvious that there was an injustice done to the victim because the victim was below 16 years and considered to be a child, and the concept of consent is irrelevant under the Protection of Children from Sexual Offences POCSO Act 2012. But the judge, I don't know under what pretext and precedent, got himself empowered to pass the orders in granting the bail to the accused. Can we call it as the inherent power that the High Court derives for giving a bail, completely setting aside the POCSO Act. According to Section 21D of the Act, child refers to any person who is below the age of 18 years, and the concept of consent is irrelevant for the POCSO cases. Even then, the victim got victimized through this verdict and the accused was let scot-free. Not just that, the weird observations of the learned Justice Sandeep Kashinath Shinde was that the victim possessed the mental capacity to actively understand the nature of circumstances and consequences of sexual act to which she has been subjected. Though the victim has alleged that she was sexually assaulted and that she was a minor and that the person who assaulted her happened to be a major and a married man. Look at the trajectory of the justice. I feel sometimes we tend to ignore either voluntarily or wantedly the well-laid and established sections in law. For example, the Protection of Children from Sexual Offences Act 2012 has been enacted to protect children below 18 years, particularly women, from offences of sexual assault, sexual harassment, etc. Whereas, if we give a harmonious construction with Indian Penal Code, which defines the offence of rape, where the consent of women below the age of 18 years is not a valid consent in the eyes of the law for any sexual activity. Even when we give a harmonious construction with POCSO, Justice Shinde shouldn't have said that the case under POCSO happened to be a consensual between a minor who alleges a rape and a major who wants a bail. In the case of Navaghare, which was dealt by Justice Sandeep Shinde, the age of the child subject was below 18, considered to be a child. But the judge's personal interpretation was that even below the POCSO stipulated age of 18, he says the girl was capable enough to understand the sexual consequences. Was it not a personal act of the judge misinterpreting the law and giving his own interpretation in his own way? If he is law by himself, yes, whatever he said is going to be right. But he was supposed to be abiding the POCSO Act, even at least while considering the bail under POCSO Act, particularly when the victim has alleged a rape. So, in a nutshell, what I would like to say here is there should be supernumerary reviews taking place of these judgments by various high court judges, because they are constrained by their own limitations of understanding, background, whatever it is. They might have become judges, doesn't mean they can deliver the judgment as they like. And if the law and the society and the custom of India has felt that Pushpa Ganediwala was wrong in her judgment of saying that skin to skin contact and sexual intent is required for an accused to be punished, then equally Justice Sandeep Kashinath Shinde, who said that even a child below 18 years is capable of understanding the implications of sexual relation, and that though consensus cannot be attributed to such acts of children below of 18 years age under POCSO Act, still he says that that can be considered as consensual, leads us to a conclusion that, hey, justice here has to be the same for all. You cannot selectively punish some and you cannot selectively grant bails to some with the whimsical judgments coming from these individuals. That is where we need standards, we need precedents, we need continuous education to the judges in terms of various acts, sections, do's and don'ts. If we don't do that, the victims will have no respect for the law of the land. Let's be clear. Let's not take the shelter under the contempt of court for raising the voice of this kind of anomalies happening in plenty in various high courts in India. Let's be alert. Judicial activism is not criticism. Judicial activism is a constructive criticism for the improvement of quality of judgments. Yesterday it was Ganadiwala, but today it was Sandeep Kashinath Shinde who just retired peacefully without any action during his tenure as judge. Means if somebody takes up and makes a noise, only then even the media in India catches and that becomes an issue and there will be an action. Otherwise, if a poor guy cannot take up these issues to a national level or to media or to any bigwigs of our society, then the justice get buried there and there only. This situation has to change. Times are changing. Time for our judges also to change along with the times. Thank you very much.